I do not know what it is.
And I'd like to talk about what they're doing with our special legal analyst this hour, David Bruno, now joining us from New Jersey, a criminal defense attorney, former prosecutor. Also with us, we still have Alicia Dern, trial attorney. All right, jury instructions. It can sound boring because right now it's a jury instruction conference. We know that's when the attorneys go through jury instructions with the judge to see which ones will be read to the jury. But David, I would argue this can be one of the most important aspects of a criminal trial. What do you think?
Yeah, no, I agree with you, Ashley, and thank you for having me. It's always a pleasure. Look, as you said, probably one of the most frequently and common areas of reversal happened right here in the jury instructions. Because it's critical. You know, these fact finders, these jurors, they have two jobs. First is fact finding. They have to make credibility determinations of witnesses. They have to determine what the evidence is, and then they have to apply the law based on what the court instructs them on the law. Now, I hate doing this now. I'm very surprised, and you're a judge yourself, Ashley. There's a better time to use this time right here instead of right before closing arguments when attorneys are trying to get ready to give a closing. And I can tell you as a criminal practitioner, when I'm in this spot right here, the last thing I want to be talking about is the jury instructions, removing things of provocation, changing them up from the model jury instructions. It could be done in conferences before as we lead up to this part. Now, I know that some of the jury instructions depends on the evidence how it comes in, but I don't think we got any surprises on today's testimony that this charge shouldn't have been agreed upon prior to this moment in this trial.
You make a really good point, because you're right. Right now is when attorneys want to be preparing and putting the final I should say, I guess, the final pieces of their closing argument together. And to your point, here's what we know to expect. Beginning at 8:30 in the morning, closing arguments. That's the first thing that's going to happen with the jury in the morning. And then after that, that is when they will receive these instructions that they're going through right now. Alicia, what are your thoughts about the jury instructions, but also the closing arguments and what you might expect to see tomorrow?
Well, I agree that it's can be distracting to do the jury instructions right as you're getting ready to prepare for closing arguments. I've had that happen to me in a few trials. It's kind of annoying. Normally you want to go in with the jury instructions, mostly agreed, and then just make a few adjustments. Closing arguments are really important because this is the time for the lawyers to pull together all the pieces of evidence and present it in a coherent story, remind the jury of what's important, of what their the theme or their theory of the case is, and sometimes to pull out some of those jury instructions and point out some of the key parts. I do believe that juries really do look at the jury instructions and try to understand them, often have difficulty understanding them, and so the closing argument is the time where you have to not only explain to them what they have to do back when they get into that jury room, but also really piece together the whole story so they can remember the testimony and remember the feelings that they had and start to feel the ring of truth to the story that you're telling.
And closing arguments is vital. That is when you get to persuade as a trial attorney. One of my favorite parts when I would try cases, closing argument, because then opening we said this is what we expect the evidence will show, but closing you get to bring it and say this is exactly why you need to either find him guilty or not guilty, obviously depending on what side you represent. All right, we know that they have gone to a sidebar, another sidebar in this case.